Welcome to episode 8 of Called to the Bar, International Law Over Drinks, a series of informal conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are, as always, speaking off the cuff and without benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. Although perhaps more peer-reviewed than usual this evening, but we'll get to that. I'm Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra, and this evening I'm joined by Associate Professor Ntina Suvala of the Australian National University to talk about her recent amazing article, Aggression, Capitalism and International Law, Missed Opportunities or Structural Constraints, which began as a lecture in the UCL Faculty of Law's Current Legal Problems series, one of the great legal lecture series in the English-speaking world, in my humble opinion, spoken, full disclaimer, as a former UCL employee. Now, Ntina, yesterday evening we had the pleasure of having dinner in Canberra, where I sampled some Lebanese wine and you introduced me to a Greek spirit or liqueur that I can no longer remember the name of, made from
Masticha.
pastica?
Masticha.
Masticha, which was very excitingly made from tree resin. What's your drink this evening?
So tonight I'm trying to be more sensible. I am having a yuzu and lime soda, non-alcoholic, since we went out last night.
Right. Well, I am being significantly less sensible than that and have a moderate-sized glass of Chardonnay. Now, while we historically like to begin these shows talking about our friendships and career paths, as between you and me, we've covered that in earlier episodes. So our new question is, Ntina, what is a skill you've learnt outside academia that you've found useful inside academia?
I had to think a lot about this. Thanks for the question, actually. So I did a lot of student activism when I was at university. Probably not a huge surprise.
No, you shock me and all the listeners. Yeah.
And like one of the things, you had to do was to print and distribute things like leaflets and things like that. But you pay by the page, right? So it was imperative that you learned how to say everything in one page or in one, or in two, space was really of the essence.
Mm-hmm.
So that really taught me, if you tell me to communicate an idea in 300 words, 700 words, and 837 words, I can actually do it, I think, relatively well.
Mm-hmm.
And that has been, obviously, for things like abstract writing, a very useful skill.
So hilariously, that idea of trying to get your point across clearly and in no more than one page was at the other end of the capitalist spectrum drilled into me in my 13, count them precisely, 13 months in a major corporate law firm in Sydney. So, some skills are plainly transferable from the front lines of, fighting the man to working for the man. All right, let's move on to our main topic this evening. We're back on questions of war, but this time from the perspective of theory, political economy, and interestingly to me, history. In your article, you argue that international law has been consistently unsuccessful and is currently singularly unambitious when it comes to naming, regulating, and sanctioning the political economy of war. In addition, you see this as resulting from the manufacturing of armaments existing in the intersection of two logics, the logic of the state and the logic of the market, and that each of these logics have mystifying or obfuscating effects. That obfuscation, if I understand your argument correctly, has resulted in the regulation or criminalization of the war economy and arms trade as being seen by lawyers as something that's effectively beyond the scope of what law can reasonably or successfully do. Now, this is a very interesting argument to make at a time when, in response to wars in Gaza and Ukraine, protesters are more than ever drawing a link between participation in the arms trade and complicity in war crimes or other international crimes. So there have been heated debates, for example, in Australia about whether Australia is supplying lethal aid to Israel. And it's come to light that the sole source in the global supply chain for the F-15 fighter jet of what are called uplock actuators that open and close weapons bay doors are made in a firm in Australia, in I believe Queensland. Anyway, we can come back to this example, but it seems to me that's a classic case of what you call in the article a structure of irresponsibility. That is, we supply one crucial component without which the fighter jets couldn't deploy weapons, presumably, but politicians have been able to claim either that this fraction of a weapon is not a weapon itself and therefore is non-lethal, or that we are not responsible for what a sovereign state does at the other end of the supply chain with its weapons. Anyway, look, I'm already down in the weeds, so you can see how engaging I found this paper. But before we get into it, would you like to start by telling us how the paper came about and what problem you were trying to answer?
Sure. Thank you so much for such a generous reading. And I also do have to say that early on, you read a part of that article. The whole argument wasn't there, and you were so helpful, especially in reassuring me that I'm not saying anything transparently wrong about especially international criminal law. We will get on how international criminal law is related. So there were a couple of concerns that brought about this article, right? There is a very intellectual or disciplinary concern, and there is a more like political concern. The intellectual or disciplinary concern is this division of labor that we have in international law between the people who do the worst stuff. So jus ad bellum, jus in bello, international human rights law to the extent one considers it applicable to war on the one hand, and things like international trade law, international investment law, international financial law on the other. And the idea usually is like, obviously political economy is relevant for the latter, but not so relevant for the former. And these are also just communities that usually don't speak to each other, right? These are like people who go to different conferences, read different texts, even the
Right.
critical voices. They're doing different things and not talking to each other.
Mhm.
And that pulls me to the broader political concern, which is that's not reflective of the world or of war for that matter, right? There is a whole infrastructure, literally and broadly, that makes war possible, right? And one
Mhm.
needs to be a pacifist or an anti-imperialist to think that there is something very interesting in that, hence the intellectual
Right. Well,
aspect.
I mean, as far as I know, it was Dwight Eisenhower who coined the phrase military-industrial complex, and this was not some kind of raving hippie standing at the barricades, right?
Absolutely. And I think that also shows how far we have come in the sense, in a bad sense, as in the fact that that was something that a US president was willing to talk about in such a central way, even though, of course, as he was leaving the presidency. And now it has become, until I would say this current wave of protest that you alluded to, it has become a much less central issue in much of political, but also, to bring it back to law, legal discourse, right? So
Right.
that is what motivated me. I was like, what if I bring these two things together?
Yeah. And I mean, you make some really interesting historical points in the paper that we probably won't have time to cover in much detail, but about the decline of arms regulation as being a core goal of international law. And, if we think about that space between the First and Second World War, it was seen as fundamentally instrumental to maintaining world peace, that there be limitations on the arms trade. But let's get to your paper. So broadly, it proceeds in several steps. First, you outline what you call the political economy of war and why it should concern both international lawyers and, as you put it, anyone who cares about peace. And then you go into quite some detail, providing a topology of critiques of the political economy of war. Then second, you take us back to the Nuremberg trial and the subsequent proceedings in Germany after World War II, and look at the trial of Krupp as one of the defendants, or one of the people who was meant to be a defendant before the Nuremberg International Military Tribunal in the trial of the major war criminals, and then the subsequent proceeding, the IG Farben case. So this was a moment when the conventional theory of German aggression reserved a big role for the industrial cartels. But these theories or conventional wisdoms proved hard to translate into law. And as I read your paper, the Farben case becomes in some ways a crucial touchstone for the rest of the argument. Then third, you look at the mystifying logics of the state and the market. I've already signaled my preference for obfuscating over mystifying, and how these prevent law fully grasping the relevant questions of harm and responsibility. And this gives rise to what you, and I've already flagged the term, memorably and beautifully call structures of irresponsibility. Then finally, you conclude, well, let's come to that in time. So, Dina, could we begin with kind of a critical term for the whole paper, what you understand to be the political economy of war? Now, as I read your paper, you survey a range of answers to this question and then come down on one side. So in the interest of time, could you just focus on your preferred understanding of that term?
Absolutely. So in this paper, I use political economy of war in a narrow sense. I use it to denote this sector of the economy, and it can be private economy, but it can also be publicly run parts of the economy that directly sustain war, but also directly profit from conducting war. Of course, what these sectors will be differs across space and time. So in the interwar period, during World War II, in the Cold War period, you can think of things like very traditional concentrated capital in the form of factories that produce battleships, submarines, weapons, things that are directly linked to war, right? I would say since the 1990s, this political economy shifts a little bit, like what these sectors are. And now, of course, we have things like private security, which became, for example, so important, and mercenaries, which became so important in the case of Russia's aggression against Ukraine. But you also have things like logistics, privately run massive
Right.
logistics companies that have become incorporated at different degrees in different states, but they have become incorporated within the logistics of militaries. Things like big tech and startups in Silicon Valley. They produce, of course, things like drones, but also a lot of surveillance technologies
Mhm.
or forms of AI, for example, that gradually states are experimenting with
Right.
introducing to military. So this is shifting what exactly it means, but I'm looking very specifically at industries that are directly implicated in conducting war, and they directly economically benefit from war.
Right. So that's really an entire ecology. And as the sort of fighter jet example I started with, often the supply chains are highly distributed and disaggregated, right? So, there's an overall vision of what goes into a fighter jet, but unique components could be where they're manufactured, could be anywhere in the world.
Absolutely. Yeah, yeah.
So, second, everyone loves a good legal story, or at least everyone listening to this podcast. And the Nuremberg trial and the subsequent proceedings are full of them. So, just to distinguish that for anyone who's not across the legal history, at the end of World War II, obviously the Allies came together and put on trial in a single proceeding the first kind of modern treaty-based international tribunal, the surviving high leadership of Germany. And that was called the Trial of the Major War Criminals. And part of their thesis there was this was not just military leaders, it was also people in civil administration. And so, for example, Albert Speer, the architect, the literal physical architect of Nazi Germany, had a role in the war economy, but also industrialists. Then the whole idea of the Nuremberg IMT was always that lower but significant players in the Nazi state would be tried in what were called the subsequent proceedings. So by courts set up by the occupying powers in the various zones of occupation. And a number of those, particularly in the US administered zone, have become sort of significant in the corpus of international criminal law. So anyway, tell us about the attempt to put industrialists in the dock at the Nuremberg IMT and then the subsequent IG Farben case.
Thank you so much first for explaining the distinction. That's really useful. So even before the end of the war, there was consensus especially between the US and the USSR. The UK was always a little bit dragging its feet. The roots of Nazi aggression were economic, that it was a form of economic imperialism, and that therefore major leaders of cartels, German monopolies essentially, needed to be part of those who would be put in trial. Now, what happened was there is a contingency here, which is the initial person charged was Gustav Krupp, because he was so central and almost emblematic of these close intertwining between the Nazi Party, the German state, and German capital. At that point, Gustav Krupp was a very old man who could not stand trial. He didn't know what was going on, basically. There was efforts, even though he was charged initially, there was effort to replace him with his son. The UK had a fit about it, also invoking obviously procedural propriety and things like that. So the idea was that this would be deferred, this being the prosecution of industrialists, would be deferred to what you described before, the subsequent trials carried out by different allies in the respective areas where they were administering occupied Germany. And the interesting thing there is there were two instances in which industrialists were charged specifically with aggression. So I'm interested more here than aggression than corporate atrocity in general. In the American sector, two cases. There was also one case in the French sector, but after appeal, everyone was actually acquitted. In the French sector, someone was convicted on the first degree, but upon appeal, they were acquitted. And the common explanation in the literature for this acquittal, but also for the fact that even where industrialists were found guilty of various crimes, for example, slavery in concentration camps, they were basically given a slap on the wrist for what was incredible atrocities. And usually the explanation for this extremely lenient treatment is the Cold War. By the time the subsequent trials had started, the Cold War had also started. And especially the United States was very keen, first, not to give weaponry to the anti-capitalist propaganda of the USSR.
Right.
But secondly, and very pragmatically, to entice its own capitalist class to cooperate in its armament race against the USSR. And if you have German capitalists going to jail for things that American capitalists were also doing, that doesn't send the right message. And I think
it's not a great market signal.
Exactly. The incentives, the market incentives are all wrong. So there is absolute truth in this explanation. Right? It is impossible to say that the Cold War didn't play a role. And if I wanted to translate this explanation in more like historical terms or like jurisprudential terms, I would say that people would say that these acquittals were contingent. They were because of a very specific historical moment. They were also the outcome of politics rather than law, right? There isn't there a fundamental defect in the law that caused these acquittals, right? And therefore,
had you let the prosecutors run, I mean, the usual things we hear, had they been given adequate time and money and resources, then eventually all of these things could have been brought within the remit of the law. But the political intervention story is because of the necessities of the Cold War, erstwhile prosecutors who wanted to go the full 9 yards were reined in or told this far and no further, or just defunded.
Absolutely. Or the judges had in their minds the broader thing, because the prosecutors ran their case very diligently, but the judges, the vibe of the bench had clearly changed. So this is a story about contingency then, and about politics trumping law. And again, I don't mean to say in this piece that this is an altogether wrong story. But I wanted to try to see if there was something that is more structural
Yep.
and something that is more legal there. If there was also something about law that contributed
Right.
to this outcome. And I use in this piece the IG Farben case, but I think a lot of these arguments that I make apply to the Krupp case pretty almost
Right.
identically. In
You spend
one,
a lot of time in your analysis focusing on the separate opinion in IG Farben as illustrating some of the constraints of law and a judicial frustration with them.
that's exactly right. So there is a separate opinion by Judge Herbert who agreed on the acquittal, but if you read the opinion very reluctantly so, and it's also documented that he wanted this to be a dissenting opinion until the very end, until there is indications that pressure was exerted upon him not to make this a dissenting opinion.
Gosh.
Yes. Speaking, and that also speaks to the climate of Cold War, right? Absolutely.
Right.
So there is something very interesting about both the majority opinion and the separate opinion of Judge Herbert. And it is that they both agree that if somebody is a quote unquote normal economic actor, then they could not be possibly responsible for waging aggressive war. And that's a common assumption and very explicit assumption that both the majority and the separate opinion make. And where they differ is that the majority opinion thinks that the Farben board was indeed such a ordinary capitalist minding their own business. All that they cared about was to keep Farben profitable and safe from Nazi retaliation. Whereas Herbert constructs the facts very differently and says, no, actually, these people were in very, very close collaboration with the Nazis. They had clear knowledge. They clearly had knowledge of the plan to wage aggressive war, and they were making active contributions to it through the way that they were organizing production. But they share this one starting point, right? Which is if you're a normal economic actor, it is impossible conceptually to be held legally liable for aggressive war. And to
So
me,
just to
it's
stop
very
you for a moment,
interesting.
like
Yeah.
that's on the one hand, as a lawyer, I kind of see it. We're trained as lawyers to pass things in a particular way. But stepping back one step as a citizen, it's not like no mining magnate in the Commonwealth of Australia has a political opinion, right? Like it's not like there is no political interaction between industry. And so to set up this sort of very hard dichotomy, you're either politically motivated or economically motivated. It's one of those things which, at some level, I kind of see the legal logic. And I can see how if I were on a bench and confronted with these facts, I might be drawn towards it. But once you've kind of stated it that starkly, the presumption that you're an economic actor means you can have no political motives. You have to sort of step back and go, what? Anyway, sorry, I interrupted your flow.
No, you didn't. That was excellent. But you know what? In a sense, I can also say it. And that's why I'm saying I think there is something deeper at play. The fact that as lawyers, intuitively it makes sense. There is something that is like, if not intuitively correct, at least intuitively plausible about it, I think speaks perhaps to the existence of something more structural at play that has made us think as lawyers
Right.
that this is
I
a
mean, I can
very
rationalize it as someone who teaches international criminal law and say, okay, well, before you conclude that there is guilty criminal intent, you should discount other plausible explanations. And so you can kind of erect this barrier to coming to a criminal conclusion by going, oh, well, it's very obviously plausible that their principal motivation was economic, and maybe that overrode everything else. So there's a structure there which might preclude you coming to certain conclusions. Anyway, please carry on.
And it is also true, right? The Farbins and the Krupps were, at the end of the day, motivated by a profit motive, right? So, like, it does describe something that was absolutely true about their function of their cartels, right? That at the end of the day, they sought to make profits and create value for shareholders. And that's what took me to what you identified as the beginning as these two logics, excuse me, of the state and the market.
Well, let's come to that now. As I understand it, these post-World War II cases illustrate for you the obfuscating logics of the state and the market. So could you unpack those a bit for us?
Sure. So when I got to that point, I was like, okay, there's something very interesting, not just about the conclusion that the tribunal reached, but yes, about the reasoning that they used to reach it. Indeed, one part of the reasoning was, as I said before, these were just people minding their own business, wanting to turn a profit in a volatile environment. And the other part was, well, what they thought was that they were indeed building armaments, but they were building armaments for Germany's self-defense,
Right.
not for Germany's aggressive war. Again, was that true or even a plausible construction of the facts? No. But to me, before we go to the facts, I'm very interested in the principle, right?
Yeah, so there's something there. And again, it really, how to put it, it was something I knew at some level, but didn't articulate until I read your paper, which is that in ordinary political discourse, we treat a claim of self-defense as necessarily precluding a conclusion of aggression. So, regardless of where you fall on the rights or wrongs of what's presently unfolding in Gaza, for some people, it is very plain that the analysis has to stop at
Yeah.
the point where Israel claims self-defense. Like nothing beyond that is relevant. Now, as lawyers, we can go where we're separating jus ad bellum and jus in bello. A claim of self-defense is about your ability to resort to violence as a state, and then a whole body of law follows thereafter. But for many, the idea that it could in any way be an illegal use of force is entirely precluded the moment you say
The
self-defense. So there's
magic world,
yeah,
self.
yeah, yeah. But so there's a sort of political dichotomy that to some extent is reflected in law there, right?
Absolutely. And that's what drove me to this idea of the joint, in this case, joint logics of markets and states. So the idea is here that modern world, let's say at least since the 19th century, is structured largely around states, right? Maybe in the 19th century in their empire, since the colonization states. And states have a number of fundamental prerogatives and fundamental aims, like the self-preservation and the perpetuation of the state within time and space is, la raison
Right. I
d'etat,
mean,
right?
yeah,
There's
I
no
mean, it's a
question
great
there.
point. It's a great point you make in your paper that, I mean, the way James Crawford, the late Saint James Crawford put it was that statehood is difficult to acquire, but very hard to lose. But it's a unique status in international law. Once you've acquired statehood, there is a presumption of continuity, whereas you beautifully put it in the paper. If you are, for example, talking about the legal rights of an indigenous group, they actually constantly have to show on the basis of an historic record that they haven't lost those rights, that those rights are continuing. So there's something, fundamental and fundamentally special about states as right holders.
Absolutely. And I have to also say that that argument is an argument I first encountered in the work of Natasha Whitley, a legal historian who's Australian, actually based in the US. Exactly. So international law and also domestic law give states a number of incredible prerogatives because they're states. The presumptive legality and legitimacy of self-defense. Of course, you have a right to self-defense because you're a state, and as a state, you're entitled to preserve yourself and your territorial integrity throughout time and space, right? Of course, we might disagree in domestic politics about how the national interest is to be pursued, but the idea that the national interest is to be pursued, and indeed is pursued, is central to state functions, and it's protected by a number, again, of prerogatives, things like secrecy, or things like executive discretion, free of, let's say, in parliamentary democracies, parliamentary scrutiny. We encounter, or think,
Right.
free of legal scrutiny, and we encounter that a lot in domestic legal battles lately about whether courts can review executives' decisions to export arms or part of military equipment to Israel and also to others.
Right, right. So even in the Australian parliamentary context, there was an enormous reluctance on the part of the executive government to even confirm the number of existing export licenses for potentially military equipment to Israel. So there were those sort of intersecting logics of, at one point, this concerns self-defense, so it's the highest prerogative of the state. And also because of the logic of national security, it's shrouded in secrecy. And only when it became a political issue was some information released to relevant joint committees of the Australian House of Representatives and the Senate, which I think goes directly to your point about how the logic of self-defense informs the logic of national security, informs a logic of secrecy, and cloaks everything to do with global armaments supply chains. Well, it's a Harry Potter-esque invisibility cloak, right? It's just
Exactly.
not there.
It's not there. It's not subject to democratic scrutiny or legal judicial scrutiny, or at least it is subject in a way that is very different to other
Right.
matters.
If you can even get it before a judge, as you point out in your paper, national security is an accepted category where you would say, oh, well, the principles of freedom of information or other ordinary principles of judicial review of administrative action either do not apply because we've parceled it out into the realm of the political and therefore it's fundamentally non-legal, or apply subject to, in the European terminology, a very wide margin of appreciation being given to the executive.
That's exactly right. And that's why most of cases that try to do that fail. There has been a recent example in the Netherlands, in The Hague, where district court in The Hague did order the Dutch government to seize specific weapons export to Israel. But of course, the Dutch government has appealed, and we don't have the final decision yet. But generally, not only around this particular crisis in Gaza, historically and throughout and across different jurisdictions, we see this trend. And that's why I'm saying this is not all contingency. There
Right.
is something here in which
The
democratic states and non-democratic states, common law and civil law,
right.
you find this deference to the executive,
Yep.
but is also usually given unusual levels of secrecy.
Right. So if I can just sort of sum up where I understand we're getting to, we have the logic of the state, which starts with the state's right of self-preservation and self-defense. That then kind of descends to a logic of national security. That descends to a logic of secrecy. And suddenly, the whole structure becomes really difficult to apply legal scrutiny to. And there may be an internalized judicial culture that this is actually improper, right? This is a sphere that is not amenable to legal regulation. So that's the obfuscating logic of the state. Can we switch to, we've sort of covered it implicitly, but could you kind of surface the obfuscating logic of the market?
Absolutely. So one of Marx's critiques of capitalism
Okay,
is...
everyone listening needs to take a drink. Dina's said Marx.
Oh no, oh no, people are about to die from alcohol poisoning. So his argument was capitalist societies are structured through a fundamental rupture between market value or exchange value, let's say, which I'll say, let's say it's the price for which a commodity is sold. Is not exactly that, but let's say that. And use value, the social ends for which we use different things,
Right.
right?
So a container to carry my stuff around has a fixed value, but a Hermes handbag has a much higher exchange value than a Kohl's leftover shopping bag.
Yes, yes, yes. And the argument there would be that the labor that has gone into the Hermes bag and perhaps into also the marketing of the Hermes bag is significantly more than that has gone into the leftover shopping bag. But in any way, even before we go into what determines exchange value, for him, it was just interesting that we live in this schism in which we want stuff because they're useful to us in some way. And useful didn't only mean necessary for our existence, it can mean also, they're pleasurable, or it could also mean they're destructive. Use
Right.
value doesn't mean that the use is virtuous.
Right.
It can also mean it's useful because it helps me blow up my enemies. That's a
Right.
use value,
Right.
right?
Right.
It's not a moral approval to say
Right.
that something has use value. It's just a fact.
Hmm.
But the argument there is that at the end of the day, capitalists are relatively agnostic about the use value of their stuff. Of course, they have to have use value so that somebody buys them. But what matters to them is the exchange value. And therefore, the fact that upon entering the market, they can exchange them for money and make profits, right? And the argument there was we're in a situation in which basically people can argue, and they can argue that plausibly is not a bad faith argument necessarily, that I have no control over how the way things that I produce are used, because the only thing I do is take them to a market
Right.
and exchange them for money in order to turn a profit. And
Right.
indeed, you might have situations in which somebody says, let's go back to the weapons industries. I genuinely hope, and let's hope they're honest. Let's assume they're honest. I genuinely hope that these weapons are only produced and only, excuse me, used for legitimate self-defense purposes.
Hmm.
That they're never used, right?
Right.
All I'm doing, to the extent that I'm acting as a capitalist, is to produce them because they are great business. And they are indeed great business.
Tiny irrelevant sidebar, Dina. You watch a lot of television and go to a lot of cinema. Did you see the original Marvel Iron Man movie?
I don't think I did.
Because it opens with Tony Stark, who becomes the armored superhero Iron Man, as an arms dealer, right? And saying, the entire point of his job is to make these weapons that are better than everyone else's, that will make America safe. And the hope is that they're kind of not used, but if they have to be used, they'll be devastatingly more effective than everyone else's. And as the film unfolds, he has to kind of reconcile himself to a degree with the implications of his weapons being used by actors he wouldn't politically approve of. But ultimately, he remains a capitalist industrialist who flies around in a suit of high-tech armor. Anyway, there's just something. Maybe there's a subsequent episode where both you and I have watched Iron Man 1 and can discuss the political economy. But anyway, carry on.
There is also in the latest season of Doctor Who an episode about a futuristic dystopia in which there is an ongoing war fully coordinating by the weapons manufacturer. I didn't love the latest season of Doctor Who, but this was actually an interesting episode.
Right, I'm an old school Doctor Who fan, so I'm going to have to catch up on that. I'm also reminded, I think the Nicolas Cage film Lord of War starts with a sequence that traces a bullet from being manufactured to it actually being fired and killing someone in an African conflict.
Yes, exactly. So the argument there is, and it's again a plausible argument. It's not just an excuse, it's an argument that hinges on the depersonifying functions of the market in which we produce and exchange things for money. I am teaching students law for a wage, and many of them will use this knowledge in ways that I do not approve of. I simply
Right.
have no control over that, and I have to keep doing it sometimes because I have to draw a wage.
I'm also reminded of Joseph Raz's analogy about the rule of law as a system to live under, and he analogized it to the sharpness of a knife, right? A knife can be used for cooking, it can be used for constructive purposes,
Yeah.
or it can be used in an assault or a murder, but the knife itself is morally neutral.
Yes. And yeah, the argument here would be you don't need to believe that perhaps a knife is morally neutral, but some of these weapons are not necessarily morally neutral. But you can actually pause and pay heed to the argument and not always treat it as disingenuous. The argument that says, in a world in which some people work for wages and some people work in or engage in economic activity in order to create profits or value for shareholders, what determines our decisions is not whether we consider things morally worthy, but whether we think they can have a particular, level of exchange value in the market.
So
And
it
my
seems to me there are two elements at work there, and then we'll probably, in the sake of time, need to move on. The first is that the market is kind of constructed as a barrier, right? On the one side, you're just motivated by profit and you sort of put things into the market, and the market is morally neutral. And on the other side of it is a different actor who picks up the product, and you sort of say, well, from my point of view as a manufacturer, it could be used for good or ill, but it's passed through the market. I don't even have to assign a probabilistic value
That's right.
to what could happen, or indeed even what we'd consider grasping for another legal logic, the logic of the tort of negligence, right? You might say, well, I've created this thing, and on the other side of the market, there might be one neutral or good use and 2,000 bad uses. Under the logic of negligence, we'd say, well, you shouldn't release that into the market. But because we have this sort of view of the market as neutral, that calculation doesn't apply, where there are actually legal tools where we could construct it differently.
Exactly. And in a sense, the Marxist argument is we don't exactly just view it as neutral. It has properties that make it, in some senses, amoral, right? Beyond morality and immorality is not simply seeing it as neutral, is not simply a function of our minds. It is a function of its function. Sorry, that was a terrible phrase, a function of its function. But that's
Very
what.
Foucaultian at some level, but anyway.
Okay.
Look, let's
That's the
actually
argument.
let's move on one step because I think we're there. So my favorite phrase in your paper is structures of irresponsibility. So I was originally going to ask you, can you expand on that? Now I'm going to ask you, can you condense on that? Can you kind of summarize the discussion we've had around the theme of structures of irresponsibility?
So I have to say again, I mostly take this idea from Scott Veitch, who is a critical jurisprudence person who has written a fantastic book called Law and Irresponsibility, in which he makes the argument that, very often we think of law as a system for organizing responsibility. Who has responsibility if a car hits a pedestrian? Whereas he says, especially in cases of widespread human suffering, what law actually does is to organize irresponsibility. And he's more interested in the role of bureaucratization in modern societies in which, we all do a tiny task of an abhorrent act, but each individual tiny task is not really abhorrent, it's fine, but it produces something abhorrent
Right.
at the end. Whereas I'm saying absolutely bureaucratization is part of it, but my whole argument is that the laws, the core laws that embody the logic of the state, and the core laws, let's say, tort and property and contract, that embody the logic of the market, create precisely this structure of irresponsibility in regards to the political economy of war. And in particular, I'm saying that very often, and we can discuss that in a later episode, the logic of the state and the logic of the market can pull a different direction, right? Sometimes, the necessity, the requirements of national security means we should limit trade or investment.
Hmm.
In this case, they're actually moving towards the same direction, right? Which is to make the political economy of war beyond scrutiny, let alone sanctioning. And I'm saying that, therefore, in this case, a massive structure of irresponsibility has been erected through the very basics of law that operate long before we reach, let's say, international criminal law, which is what I was dealing with in Nuremberg, or let's say human rights law, or even the law of state responsibility. So that's the main argument, that there is something fundamentally defective here. Or you don't need to agree with my moral of political evaluation, but there is something fundamentally distinctive here about how armaments are treated by law.
Well, I think that actually answers what was going to be my final question for you, which is where, in terms of conclusions, does this leave us? Which is that the entire legal structure operates, in your terms, to make the political economy of war beyond scrutiny. And I think we've had a fairly thoroughgoing examination of that. Dina, thank you.
Thank you. Just can I add a tiny, tiny postscript?
Sure.
By all of that, I don't mean that things cannot be better or worse within that structure.
Hmm.
Things like law can play a role into making this obfuscation worse or better.
Yep.
But in a sense, I'm saying its capacity is somewhat limited by very fundamental choices. That's
Right.
all. Just to say, this is kind of gloom and doom, but it's not like that strategic litigation
Right.
or efforts to reform cannot achieve anything.
Right, right. No, you're leaving space for the kind of Koskiniemi argument that however limited, law always remains a space for contestation.
That's exactly right. Okay, I have a question for you, Dag, before we
Mhm.
head out,
Yep.
because I am seeing something that our listeners are not, and I want you to just tell us what you're wearing, because people will not believe if I say it.
Oh my goodness. Okay. Well, I have wrap-up questions for you, but yes. So it's been a longish day in Canberra where I've attended a number of conferences and we're meeting beyond the cocktail hour. So entirely atypically, I am in Levi's and a Uniqlo t-shirt with the Great Wave on it. So yes, I do own loungewear and I do occasionally wear it. But just as a doctrinal lawyer, kind of coming to your paper,
Yes.
a couple of reflections from my point of view. One, I think one of the things your paper really nails is a popular view of complicity. At what point are we making material contributions such that we should see ourselves as implicated in the crime? And one of the things your paper flags is that for law, intention is the big divide there. And if we can erect plausible alternative intentions that you have to clear first, you might never get to the criminal intention. But there's something about the popular consciousness at the moment that goes, no, 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 wait, if there's a kind of but for causation on the material contribution, that should be enough. And that's really interesting to me because the first time I lectured responsibility in international criminal law at University College London, which I think may have been the year you did your master's there, but we never, our paths never crossed. I sort of drew a chain of events on the whiteboard going, okay, well, there's the person who shoots the gun and kills the victim, and they're obviously responsible. But if an accessory gives the person the gun knowing they're going to commit the murder, they also bear accessorial liability. But why does not the vendor of guns or the manufacturer of guns equally bear responsibility? And the point I was trying to make was that at some point, we kind of have to draw an arbitrary distinction in a chain of causation about who we hold criminally responsible. And at least in the Anglo-American English-speaking tradition, we draw that based on, to some extent, shared intention or maybe foreseeability of harm, depending on the kind of mental state we're talking about. But those are not the only ways we can conceptualize relationship to a crime or a bad outcome. So, in some or many Indigenous communities in Australia, if a car is driven recklessly and one of the people in the car dies as a result, everyone who is a member of the relevant community in the car is equally responsible because your job is to keep each other safe, right? So there are different ways of constructing responsibility. The other thing that kind of your paper makes me think about is a sort of aphorism of Philip Allitt's, who like to reject the entire field of international criminal law because the classic statement from Judge John Jackson of the US Supreme Court at the opening of the Nuremberg trials was that crimes are not just committed by abstract entities, they're committed by men. And by abstract entities, he meant states. And
Yes.
Allitt's point was always international crimes are not committed by individual people, they are committed by abstract entities. And his critique of international criminal law was essentially to say that by sheeting responsibility home to the individual, you excuse the state as a structure that is corruptible for criminal purposes.
Exactly. Thank you. And also, I would say my additional thing is, and we are also excusing the obstructing functions of the market in
Right,
creating a morality as necessary in order to survive as economic actors to an
right,
extent.
right. Or, yeah, in my kind of conceptualization, I guess, of what you've said this evening, the market becomes a kind of amoral filter, right? There's acts on one side of the market and acts on the other side of the market, and the market is this clean break between the two. All right, our wrap-up questions. We are over time, but we enjoy speaking too much. So, what recommendations do you have for anyone who would like to know more about what we've discussed today, other than your excellent paper, which I'll include in the show notes?
I really appreciate, yes, you doing so. So, Joanna Kyriakakis, your former colleague at Monash, has an excellent book on international criminal law and the international criminal liability of corporations. It's
Yep.
called Corporations, Accountability and International Criminal Law, Industry and Atrocity.
Yep.
And it has an incredible breadth and depth of any sort of encounter between ICL and
It's a genuinely terrific book.
yes,
Um,
absolutely.
as a more senior colleague, I was always sort of saying, Joanna, publish the book. If you publish the book, you get promoted. And she's like, oh, it's not right. I need to include this more material. And I was like, it's good, but no, it's a terrific book.
I agree entirely. So the other one, which I alluded to earlier, is Scott Veitch's Law and Irresponsibility on the Legitimization of Human Suffering. It does what it says in the can, and it deals with, and it has a whole chapter on the nuclear weapons advisory opinion,
Right.
the ICJ. So it has also an international
Which plays a
law.
significant role in your paper that we haven't managed to cover this evening. Yeah.
Absolutely. And finally, for those who are interested in the political economy of war part, Anthony Levinstein's The Palestine Laboratory. Anthony Levinstein is an Australian journalist, and he has written a terrific book on the ways that Palestine has, for many decades, been basically a way for Israel to advertise its military industry and to promote overseas weapons and especially high-tech weapons manufacturers as quote unquote battle tested.
Right. Last two wrap-up questions. First, potentially challenging. What would you be if you weren't an academic?
Oh God, I think I have to admit that I have very few skills beyond.
Professor Holly Cullen in the last episode said a barista, which, you know.
Yeah, no, I would say if I can just pick a job I think I would enjoy without any sort of like realistic restrictions, I would say pub owner. I think I
Right.
would love being a sort of like rude but loving
Yeah,
pub.
yeah, yeah.
But in
No,
a
I'd never thought of that as a job for you, but actually, particularly in the British context, I could see you as a landlady.
yes, exactly like
The
that.
kind
I
of person
feel
who
you.
walks around calling everyone darling and, acting outrageously.
Exactly. So I think I would love to do that. So, and I will not like come up with a more practical one. I will stop with that.
Oh
I
no, no,
think I
that
would love
that
to do
sounds that sounds fine. And look, you've talked about your current escape routes before, in particular your very broad love of television and cinema. Is there anything you're watching or reading or listening or doing at the moment that takes your mind off international law particularly?
So it's not a reading, watching, doing, but I have a kitten and I love
Ah,
it more than
yes.
anything else.
And what is the
And
name of your kitten?
she is Margot, and she's a 10-month-old white fur, blue eyes ragdoll, and she's the prettiest cat in the world.
I will attempt to include a link to an image of her in the show notes, but I have to ask, is she Margot after any particular Australian actress of international renown, or is it just a name you settled on?
No, actually, your partner was the only person who figured out what it is immediately. It's just a pretty classy French name.
Right, of
Yes,
course.
it's not after Margot Robbie. It's more like a fancy Parisian lady called Margot.
I love that image for your kitten, and we'll try
Thank
and put an image of your kitten into the show notes. Dina,
you.
it's always a pleasure, and it's always a pleasure to talk work concepts with you. We've probably run over time, so I'm just going to say thank you, and to our listeners, thank you for sticking with us, and bye bye.
Thank you for listening.